One of the issues that parent forums have repeatedly raised is the change that's happening to the way in which schools are funded, and in particular the way in which high-cost SEN needs are going to be funded in the future. And my understanding is that the new approach is that schools are going to be responsible for the first £6,000 of high-cost pupils provision, and they're supposed to be meeting that from their notional SEN budget. And that obviously gives rise to concerns of what about if that budget's been spent on other pupils. From a legal perspective, the key duty to meet children's special educational needs is with the local authority, because they have to assess, and at the moment they have to produce the statement, and the statement then has to be implemented, and that's an absolute duty. And that won't change under the new scheme with education, health and care plans. It will still be the local authority's job to make sure that provision is made. So in a case where a child has a statement or a new plan, then the legal obligation is on the local authority to make sure that all the provision that's necessary to meet the child's educational needs is made. And if the school can't afford to do that because of the way in which the new funding formula works, then the local authority will have to top up the funding, otherwise it will be in breach of its duties towards the child. The more complex issue arises in cases where the child doesn't have a statement or a plan, because there the local authority's involvement is limited, and there is a duty on the school governors to use their best endeavours to make sure that special education provision is made for all children. But a best endeavours duty is obviously limited, and it may be that having tried their best, the governors aren't able to do it because they haven't got enough money. And that, in my view, is going to remain one of the key triggers for the statutory assessment process. Because at the moment, to have a statement, to need a statement, one of the key requirements is that the school isn't able to meet your needs from its own resources. And there's no reason why that should change when the EHC plan comes in either. So in cases where the school can't afford to meet the needs, that will be an obvious trigger point for a statutory assessment, leading at the moment to a statement, or under the new system to a plan. And once the statement or the plan is enforced, then the local authority will have the duty to make sure that those needs are met. So I understand the concern that parent forums have about funding changes, and they're very important in practice, but in law it doesn't make that much difference to where the legal duties lie.